Hello, everybody. You got a new face behind the camera today, or a different one, I should say. I'm not new, but it is a different one. And boy, do I have some stories for you. So I'm Deb Keither, and I am going to give you a new storyline for you to get engaged in. And boy, is it a doozy. So it has to do with a lot of moving parts, and we're going to take a look at, and it kind of intersects with my case against Milwaukee Public Schools. It definitely intersects with that. And it's something that is very unique. So I'm excited to tell you about it today. I'm going to take you through a few documents. So let's get ready to do that right now. And let me kind of just lay the background. If you haven't been paying attention to, or you haven't had an opportunity to catch the story that I'm involved in with my case, which is Keither versus Keith Posley and a variety of other defendants in Milwaukee Public Schools, I have in our library on deliberate indifference, Wisconsin, there is a set of 2 videos where I go through my complaint. I'm not going to do that today. I think it's important if you want to see it and you want the context to kind of see how all the background plays out, you can go back and watch those. But it's important. I'm going to start there because I want to just point out a few things that are critical to leading up to the story, this crazy story. So you'll see right here, I've got my complaint that was not dismissed, by the way. So my complaint is in federal court. It has survived 2 rigorous dismissals attempts by Milwaukee Public Schools and their counsel from Von Briesen. And it remains on the docket with 16 defendants, including Milwaukee, the Board of School Directors, and 15 other defendants in their individual capacity. Now, that's important for this story because one of those individual defendants is a former colleague of mine and one that I reached out to, not just me, but several other people reached out for assistance when I was being retaliated at with Milwaukee Public Schools, and I was directed to go speak to this individual. Well, that individual was a deputy superintendent at the time. His name is Kelvin Ferman. He had come to Milwaukee Public Schools as a district attorney for the city of Milwaukee, where he worked exclusively, not exclusively, he spent a majority of his time working on Milwaukee Public School cases. There was history of him making a contract and bringing in the superintendent that recently was just resigned, and quite shame, Keith Posley. And Keith Posley brought him over to the district, and he served as a deputy superintendent. I do the air quotes because it is my opinion that he, and many other people's opinion, including board members, that he served as the superintendent's personal counsel. So he was a deputy superintendent for maybe 2+ years, and then he left Milwaukee Public Schools in pretty big drama and high fashion, and we've looked at a lot of his exit surveys and information that he provided about MPS and the dysfunction there. All things that I had been saying since 2020, and actually had came to him for guidance on how to deal with those things. And then Calvin went to Bulow-Vetter Law Firm. He was there for 1 year. Bulow-Vetter intersects with my case as well because the district is paying for that law firm to represent third-party witnesses in my case. So he left totally engrossed with all this background from Milwaukee Public Schools, and then went to be an attorney at Bulow-Vetter. He was there for about a year, and then he is now, we stumbled upon the fact that as of April 2023, he is administrative law judge in the Wisconsin Equal Rights Division, where all of these MPS cases are flowing through. So what do you know about that? And what you're going to hear, not today on this particular segment, but we're going to go back in and also show where Calvin has, been a part of ongoing discussions. The ALJs discuss MPS cases. I have open records where I am cited, and there are things that they redact from the Wisconsin ERD where they are discussing my case. So, but that's not for today. What I want to show you today, and I'm going to take you through the screen right here. I said that I've read this before, so you can go back and read it if you'd like to, but I am going to show you something. I put the word Ferman in here. Ferman is a huge factor in my complaint. If you just look, there are 43 mentions of him in my federal complaint. So he was a major player. He was the person who called me down and kind of ambushed me with a reassignment. He was somebody who had a legal background in working with Milwaukee Public Schools and providing legal advice to them in his capacity as a city attorney. He also, there are communications that we have from open records where he had discussed like what to do with me. And so he's definitely a major player in my case, and I kind of just pop through here to show that, wow, he's in here. And I have a lot of document evidence from him, a lot of interactions with him that are all part of my case. So let's fast forward a little bit now, because that's not what this is about. What this is about is once Calvin Ferman became a Wisconsin equal rights judge or hearing examiner, he got himself into the position, and he served Ben and I with a lawsuit for defamation. He did not like that we were talking about our experiences or sharing the primary sources on the YouTube page, that we were being transparent. He did not like that. And so one day when I was at my home, and I could even put this video up if we so decided we wanted to see it, but the process server that he hired came onto my yard, totally uninvited, would not identify himself, and followed me to my backyard even after I told him to leave my property 2 times. And I did inform him that he was being recorded because I have a series of cameras around my house, and this was caught on tape. And he continued to follow me around to my backyard and my back door, and he whipped about a 50-page document at me. What I later found out, the document was the document that I have up on the screen right now, where the equal rights judge, the one that I have 3 probable causes from his department, their investigators, Mr. Calvin Ferman, is suing us. And he is suing me and Ben. He has asked for $750,000 because of his... First, he said this is an intentional tort. Let's see, there it is. Intentional tort. Now, intentional tort, just... what I've learned in Calvin having discussions with the attorney that represents us, which is not Ben, that intentional tort there has to be some interference with your employment. You have to have some losses. You have to have something that happened that impacted you as a result of things that people say about you that, first of all, aren't true, and that they aren't true. Now, I won't go into that stuff because I'm not a lawyer, but I do know that everything that I have presented is all part of the legal record. So any document like Calvin's exit survey that he authored and that I got from open records, I shared. He didn't like that. I shared the deposition of Calvin Ferman, which was 7 hours that I paid for, which is several thousands of dollars. He didn't like that was posted. And by the way, that's all been put on this deliberate indifference station or YouTube channel. So intentional tort, although now Calvin has admitted that he does not have any losses, it's the $750,000 is due to his not liking the fact that we are posting truth on our deliberate indifference station. So I'm not going to read through this because take a look. It's 48 pages. He has written 48 pages of the things that are bothering him. And as you can see, he names me and Ben. He pulls out the background, but I kind of want to highlight some of the things that he has written down. He's got a whole section on this. He's got like 3 pages of all of his accolades. So he wants everybody to know all of the things that he's done in this complaint, areas of, specific areas of law that he's covered, things that he's done, where he's worked. He was in the Marine Corps. And then, then he just says my name. So he makes a accusation that I am working as a paralegal, which is completely false. But that's what he put on here. So as he gets into here, I'm just going to pull out some of these, but his big thing is that he is very irritated by the YouTube channel. And he's got, Debbie's posting these things, whenever a video is made, I sometimes will put that on my social media. And so he's writing that, my goodness, how dare she post these things on her social media. And he pulls out LinkedIn, being especially vulgar to him because LinkedIn, in his opinion, is only for certain things. He certainly shouldn't post anything of this nature on a LinkedIn page. So here we go. And he says the defendant's YouTube channel has over 5,000 followers, or more than 5,000 different individuals who support the content of the channel and subscribe to the channel. So he calls us, he says, we are not news people. We're not a news organization. So here's his first one, defamation number 1, false statements that plaintiff Ferman engaged in a conspiracy, a coup, and a plot to oust the MPS superintendent of schools. I guess he's referring to the fact that we posted his exit survey and took people through his exit survey. We can post that again, but he writes very specifically about the dysfunction, the failures, the things that he feels he has tried to, address and have not. There has been no action, so he really throws the superintendent under the bus in those particular documents. So here he's mentioning them right here, and he doesn't like those. So, and he's got the different artifacts in here. Then he goes in to break down, conspiracy is a commonly defined, it means an agreement between 2 or more persons. So he's kind of challenging us on, your idea of conspiracy is this one, and you certainly could have never have said that, even though he said similar things in his exit survey. So he quotes Ben saying, hello again, this is Ben Hitchcock Cross talking to you today for deliberate indifference and the plot to remove Keith Posey from superintendent of Milwaukee Public Schools. And by the way, the superintendent is removed, and that's all over the news. And you can read a lot of the news cycle because it's under the fall of a leader, or a superintendent. So, it's like we were doing it 2 years earlier than the other news cycle because we had all the primary sources. So he also talks about the definition of a coup. So he, obviously this is our definition. And if we were to ever say this word, we need to understand that this is the way that Calvin Ferman understands that word. And the fact that I'm a whistleblower and he's the one who reassigned me, none of that he doesn't factor any of that into this discussion. He talks about the filing of a whistleblower complaint is not an unlawful or evil act. Of course it's not. I had to file several myself, although I didn't get promoted. I got locked in a basement, but other people got accolades for doing such. and by people who later went to go file them too. So he is making all kinds of claims that we obviously shouldn't be talking about our personal experiences. I shouldn't be telling my story. I should not be sharing things that are part of the legal record, according to him. He doesn't like that. Mr. Chasen's notebook is something that we got in. He talks about that here. In the complaint, we got those through expensive motion processes, through legal processes. Those are mine to share. So I can read those to people. I think they're important. I think it's important to understand how all these entities are playing off one another. He goes into the definitions of what is an attorney. And as you can see, like, we are not even a little bit into this. We're on page 15, and this document that he wrote is 48 pages long. And he goes on and on about the YouTube videos, how it's defaming him, although he can produce no employment claim or nothing is related to any loss for him. It's really just that he doesn't like we're doing this, and he has conceded to that. And I guess he assumes that I edit many of the videos. He writes that in here. Defendant Keither, I caused the false and defamatory statements to be published by my participation in the preparation, editing, and posting of defamation videos, number 1, and defamation video. He's just got defamation video number 1. And there are comments. He pulls out many comments as well in here. Let's see if we can find some of his comments, because he just, look, here, this one made me chuckle too. Point number 81 on page 16. At the time, Plaintiff Ferman viewed defamation video number 1 on November 9th, 2023. Defamation video number 1 had 887 views, 20 likes, or 20 different individuals expressing support for the content of the video. This is what this equal rights administrative law judge is spending his time doing, is quantifying this nonsense and sucking up the court with this. I mean, it blows my mind. Let's look at defamation number 2 really quickly. Defamation number 2, false statements that Plaintiff Ferman engaged in a coup and a plot to oust the MPS superintendent of schools. So he's referencing a video that we have called Matt Chasen and Calvin Ferman correspond to oust Keith Posley. This, again, was part of all of the documents we have available. We have their correspondence. We have their notes. We have them from the district. That's the only way that we have them. And from going through a very lengthy and expensive process of obtaining those. So, of course, have a right to share those and to talk about them. They're our experience. They're part of the formal record. He goes on and on about all these definitions of a coup and a plot and a conspiracy, just page after page after page. Here he quotes Ben again. Hello again, this is Ben Hitchcock Ross. He sat here and dictated this stuff. Here's his plot and his coup again. He's thinking we should not be allowed to use those words. We certainly don't believe them. And, that's defamatory to him. I can tell you something. I believe them because I went through it. It was my experience, and I have the evidence that has withstood the dismissal process. And I also have won probable cause in very lengthy investigations where they talked to many people. And so for me, for him to suggest that I don't believe these things is like really odd. Here he goes on again to that, we should know better. We have this knowledge. We know we're saying things that aren't true. It's not, it is true. And that's what the evidence shows. That's what all the witnesses show. 20 witnesses, thousands of pages of documents. So I just don't understand why he can't understand that. Let's see. Here's one. Additionally, defendant Hitchcock Cross acted out of ill will and revenge because plaintiff Ferman opposed a third-party subpoena for documents that defendant Hitchcock Cross served on him in defendant Keither's employment discrimination matter. I have no idea what he's even talking about here. Ben and I have never discussed this. It is so cooked up. And for him, now he's like projecting these falsities out here to kind of like preemptively strike things. But, you know, it's simply not going to work. He's got no evidence of that. Those things never happen. It's just way out there. So we could, if people wanted to read this, we could have a video where we read it. But I really just wanted to highlight some of this as, again, part of the unfolding story. He's got a third defamation claim in here, false statements that plaintiff Ferman is a bad actor, a liar, and is unqualified and biased as an administrative law judge. I can tell you again, and I am going to say this, in my storyline, okay, and my documents, everything that I have created up to this point, and Ferman and I go back to October 6, 2020, and even prior to that, because that was our face-to-face meeting. He is part of my story, and he is a bad actor in my story, period. He did not do the work that he was paid to do. He acted in a manner which, again, it's in my complaint, so I won't break it down here, but we do believe these things, and we believe them because we have the evidence. So let's see if we can get in here. Oh, and here and this really gets to the crux of it. I'm on page 24 now, and I'll continue flying through these because we could be here all day with his lengthy breakdown of everything that is making him upset. But here's number 119. Defendant Keither acknowledged that Superintendent Posley is the alleged bad actor in her case, and not plaintiff Ferman. There is more than one bad actor in my case, okay? And I can tell you very discreetly and specifically why certain people are bad actors in my case. And you are one of them, Calvin. When we came to you, we gave you evidence. We gave you significant amounts of documentary evidence. We asked for your guidance. We were directed to you. And you know the choices you made, okay? You did not do an unbiased investigation. You did not treat employees with any respect. I even said to you on our October 6, 2020 meeting, I know coming to you is going to put a target on my back, and you laughed at me. And luckily, there were 2 other people in the room with me. Those are witnesses in my case for that particular circumstance. So I'm sorry that you think there's only one bad actor and that you aren't to be included in that feeling or that sentiment, but you are. And I believe that, and I know that. So I'm going to keep flying through here. He's got, every time I want to fly through something, I find something that's kind of funny. Here's it's not funny because it's Calvin Ferman spent time doing this because he thinks it's a legitimate use of the court's time. Number 126. Defendant Hitchcock Cross's written description attached to the defamation video states, Wisconsin Governor Tony Evers hires Calvin Ferman, former Bulow veteran and Milwaukee Public Schools attorney. With Democrats like these, who needs Republicans? It's a good question. I ask that question a lot. Was there no one else who did not have 5 hours of depositions and a record of working against workers? I mean, to me, that's a major slap in the face that the investigators who gave me probable cause, and they did a lengthy investigation. I have over 100 pages of different investigations. They know Calvin Ferman's role in my case. And then they went and hired him as a judge or a hearing examiner for other discrimination cases when he in fact participated in mine. That's weird to me. It doesn't make sense to me. So going on here, he doesn't like the hashtags we use. That's very offensive to him. He picks out certain people's comments, and he doesn't like that we have allowed those comments to remain posted. He talks a lot about Beulah Vedder, which was an employer of his that he was at for just a little over a year, or somewhere around a year's point, right during my case. As a matter of fact, when we deposed him, he was an on-staff attorney with several other former city attorneys turned MPS employees turned Beulah Vedder. And, Dan Valite is a namesake on the Beulah Vedder law firm, and he has a lot of background on the specifics and the Miriam Horowitz investigations that happened on Milwaukee Public Schools. He was on paid stipend to give, or retainer to give input to Jacqueline Mann and Matt Chasen. Those are things that are in the record. They're in the deposition. They really aren't disputed in terms of what I know and what I believe. So in scrolling through this, and I also think that, wow, for a judge to sue an attorney and an employee that has been so much harmed by actions that he participated in is just like, it's not the essence of the Equal Rights Division that I'm aware of, that I know about. So I'm going to keep going. This is a whole long one. He really breaks down just about everything that's ever, been said with his name. It's all kind of his feelings about it. He's feeling it's very unfair. And so in getting to the end here, I was going to see if on this particular one I have some of the exhibits, but I'm not sure I do. I'm kind of scrolling through here, and I see that I don't think I have the exhibits on this particular item, but the exhibits are really very telling, because he posts things like, this is a Google search. This is what comes up when you Google search me. Those are the things you did. So that's what's going to come up when you put your name in and you Google search you. That's what's going to come up. I don't like the things that I have attached to my name now because of, I never wanted to be a whistleblower. I never wanted to have to spend my time doing this stuff. So I don't really appreciate that what comes up when my stuff is Googled. But you know what? It's the truth. These are true things. And if you don't like what's Googled about you, then you should, think about what exists around your experiences and what records you lay in your actions and your behavior and the things that you write. That's how you can control that. He also demanded a jury of 12 people. And by the way, we've already had at least 4 court appearances during their workday. So he, as a judge, he slates time where he's, I guess, off of work. And he is, he doesn't write this during the workday, I'm hoping. But he does have to attend court proceedings during the workday. And he's already had to do that at least 4 times, because I've been there 4 times. And so not only is it expensive and, taking up time in the court, but he is also away from his post at the Equal Rights Division so that he can take on one former employee that was victimized and her attorney, my attorney, which is Ben. So I'm going to stop here, because the next video I'm going to do is going to be about, or maybe this will just break here. This can be a cutoff. I'll keep recording and I'll just do another part.